Hello people. Today we are going to discuss a recent judgment given by the division bench of the Meghalaya High Court, that is Cheerfulson Snaitang versus State of Meghalaya. This case involves a 10-year-old rape victim, and here the Meghalaya High Court had upheld the decision of the lower court which had convicted the accused. So, let us briefly understand the facts of this particular case and further what the Meghalaya High Court said in this regard. This matter happened on September 23rd, 2006, and in this respect, a complaint was lodged on September 30, 2006. Further, the minor was medically examined on 1st of October 2006, and this medical examination revealed that the victim's vagina was tender and red and her hymen was ruptured. The medical examiner was of the view that the nature of the tear of the hymen in this case indicated that it was upon being pushed by a foreign body and not due to the victim being involved in any kind of other sports activity. Further, it is important for us to see that the accused had confessed to the commission of the crime in front of the local darbar. However, such an extrajudicial confession could not have been taken cognizance of. The trial court merely referred to the statement rendered by the appellant or the accused under Section 164 of the Code of Criminal Procedure, wherein he clearly admitted to having been raped the victim. There were various contentions given by the appellant. In support of the appellant's case, there was no rape, and it was the victim's oral evidence at the trial that was basically relied upon. In the course of examination in chief, the victim claimed that the appellant grabbed her and took her to the bedroom, where he made her lie down, and then he took off his pants and further took off her underclothes, and then he raped her. However, in her cross-examination, the statement differed a bit. She said, "I did not feel any pain after the accused had raped me. In fact, the accused person did not penetrate his male organ inside my vagina, but he just rubbed from the top of my underclothes." According to the appellant, the victim's underclothes were not taken down, and the appellant merely rubbed himself on the victim's crotch while she still wore her underpants. There was no commission of the rape. Let us see the court's observation in this case. The court held that even if the victim's evidence in her cross-examination is taken at face value, it would not imply that there was no penetrative sex. If it to be accepted that at the relevant time the victim was wearing her underpants and the appellant rubbed his organs from above her underpants, there was no difficulty in penetration. In any event, by virtue of Section 375C of the Penal Code, when a person manipulates any part of the body of a woman as to cause penetration into the vagina or urethra, the act would amount to rape, and there is sufficient evidence of such penetration in the present case. The court further observed that whatever may be the reason for victim claiming that she did not feel any pain at the time, but she complained of pain when she was medically examined on October 1st, 2006, and even the medical reports confirmed the same. The medical report also confirmed the tenderness in her vagina, which also revealed redness and the ruptured hymen. And the court even said that merely because the victim may have not said that she did not endure any pain at that relevant time may not absolve the appellant herein of his guilt. Subsequently, the court held that on an overall appreciation of the evidence, it does not appear that there was no penetration in the course of the appellant forcing himself on the victim on the relevant dates, and accordingly, his conviction for the commission of rape was affirmed. Therefore, the Meghalaya High Court held that rubbing male organ over the vagina or urethra of victims' underclothes would even amount to rape. Thank you.